All right, I think we should begin now. So I would ask those of you who are speaking, either take a place or maybe go back there to talk. Thank you very much for being here for the panel. I'm the moderator of the panel, Christopher Kuner of University of Copenhagen. And this is the panel on moving toward a sustainable and functional EUUS data transfers framework, and you'll notice there's a question mark at the end of the title, and I think there's a reason for that. So we can hopefully elucidate some of the questions, perhaps, that relate to the uncertainty. We have a full panel today, but before we get into a panel discussion, we're honored to have the participation of Commissioner Didier Reynders, who's of course, the Commissioner for Justice in the European Commission, which also has who also has a responsibility for the discussions about the EU-US data transfer framework. So it's really wonderful, Commissioner, to have you here. We appreciate it, and I would give the floor to you then for your remarks, please. Thank you.
Thank you very much, and thank you very much for such an invitation. Good afternoon to all of you, and it's a pleasure to be with you this year in person, because I took part of different discussions by video, but now it's a pleasure to see many people in the room, and congratulations to the organizers for putting together a very interesting program and a world-class conference. And I have seen in the program that with those topics on the agenda, you will keep me for a part, but certainly many experts of the Commission very busy. They will explain that maybe later themselves, because the protection of children's privacy, trustworthy AI, international data flows are some examples of these very important topics that we are working on in the Commission, but it will be possible to explain maybe also to you later on. This year's conference is all about the ideas that drive our digital world, but equally important for the European Union are the values it is built upon. And you know that in this Article 2 of the treaty, we are building the Union on the fundamental rights, democracy, and the rule of law, and we try to take care of all those values in all our actions. Digitalization is improving our life in so many ways, but we must mitigate the risks to our fundamental values, just as we need checks and balances to defend them. As our work on transatlantic data flow shows, addressing these challenges is far from being a walk in the park. But addressing these challenges, including through active engagement with our international partners, is entirely necessary to ensure that the EU's values are fully upheld in an interconnected world. It is also necessary if we want the European Union to contribute to shaping the rules of the game at the global level. This is even more important when other actors defend very different values. And so we try first to organize the protection of our values in the European Union, but we try also to be sure that the protection will travel with the data when we organize a transfer of personal data to other parts of the world. And when we are doing that, it's not only to protect the personal data, but also to convince some partner to be, if I may, like-minded partners, and to have the same level of protection, the same kind of protection that what we have tried to organize at the EU level. And the panel will discuss later how we are doing this with the new EU-US framework, but you know that we have a network now, if I may, of adequacy decisions with many partners, and we have seen that it was possible to have similar approaches on the 5 continents that the approach that we have had with the GDPR. So it's become to be a real standard at the EU level. But before we hear from the excellent speakers, allow me to briefly set the scene. When the Court of Justice invalidated the EU-US Privacy Shield in its 2020 ruling, the court did so for 2 reasons. Firstly, it ruled that the agreement did not provide for sufficient safeguards against access to data by US intelligence agencies. In other words, the extent to which US intelligence agencies could have access to Europeans' data was not sufficiently limited in terms of necessity and proportionality. Secondly, it ruled that there were insufficient safeguards in terms of individuals being able to seek redress if they considered that their data was accessed abusively. This ruling gave the Commission a very clear negotiating mandate. It was clear from the beginning that the new framework would have to be very different from the previous one because the court set clear requirements. And it was clear that all negotiations with the US would revolve around necessity and proportionality, a safeguard, as well as around redress, the two main concerns expressed by the court. I led negotiations for the EU over over 1.5 years, and I must say that I've started to discuss with my US counterpart in December 19 about a possible decision of the court. Then we have discussed about the decisions, and then we have started negotiation for around 18 months with Secretary of Commerce, Gina Raimondo, and the Attorney General, Merrick Garland. These were not easy negotiations. They were complex as they concern one of the most sensitive issues for any society, the balance between individual rights and collective security. What we have achieved, as recognized by the European Data Protection Board itself, are very significant changes to the US legal framework to address our court's concerns. The executive order signed and issued by President Biden last year creates new rules that regulate how and under which conditions US intelligence agencies can collect and use personal data transferred from the European Union. These safeguards are binding on all American intelligence agencies and ensure that any access to data will be limited to what is necessary and proportionate to protect national security. Moreover, all Europeans will be able to invoke these new safeguards to obtain redress if they are breached. This is very different from what we had in the past. Just to mention one example, under the Privacy Shield, complaints from Europeans were handled by an ombudsperson established within the US State Department and without real adjudicative powers. Today, and it was a long discussion and we continue to discuss about the implementation of it, but today individuals will have the possibility to turn to an independent tribunal, an administrative tribunal, a new data protection review court, if they consider that their data was unlawfully accessed by US intelligence agencies. Unlike the ombudsperson, the new data protection review court will have the power to investigate such complaints and issue binding decisions. It will have the power to order remedies, such as the deletion of data that was unlawfully collected, for example. Importantly, these new safeguards will apply to all transatlantic data transfers, not only those based on the future adequacy decision. This means that companies using order transfer tools such as standard contractual clauses or binding corporate rules will also benefit from them. As shown by the recent decision of the Irish Data Protection Commissioner in the Mete case, these are no theoretical issues. This should significantly increase legal certainty and stability for EU-US data transfers, while comprehensively ensuring continuity of protection of Europeans' rights. The safeguards we agreed with the US are not only a significant improvement. We believe that what we have negotiated with the US meets the court's requirements. We also believe that the solutions we have negotiated with the US are in line with how Supreme Courts in EU member states strike the balance between privacy and national security. This is in line with the courts in Strasbourg and Luxembourg. What are next steps? For a start, the European Data Protection Board requested clarifications, and the European Parliament raised certain issues in its resolution of the 11th of May. My services are currently working on the revised version of the draft adequacy decision. After this, representatives from the EU's member states will weigh in if and when they will give their green light to our draft, the new draft. The Commission will be able to adopt the final adequacy decision. But as the draft adequacy decision clearly states, it will only enter into effect once the new legal framework is fully in place on the US side. For this to happen, the US needs to implement the safeguards introduced by the executive order. US intelligence agencies must revise their national internal rules and procedures to ensure that the agreed safeguards are in place. And so they are working now for some amendments to their internal rules and all the different documents to be sure that we have such a kind of situation. And we understand this work is well advanced. But the US must also ensure that EU citizens have access to the new Data Protection Review Court. In practice, this requires the US to designate the European Union as an organization that can benefit from the new redress mechanism. More than that, the European Economic Area, so we will work also with Norway, Liechtenstein, and Iceland. And we expect this to happen soon. Without this, a key requirement of the court will not be fulfilled. And so it will be important to have new rules in the internal rules in the intelligence agencies. It will be important to be designated as an organization that can benefit from the new redress mechanism. Of course, it will be important also to have the new court into place. So we are waiting for all those evolutions on the US side. And when will the new adequacy be adopted? It is difficult to give a precise date, as this is a process that involves different actors on both sides of the Atlantic, but we are doing all the necessary steps to allow an adoption by the summer. So we'll see on all sides. We're quite sure that it will be possible to be ready. I'm hoping that it will be the same on the different requirements on the US side. The outcome of these negotiations shows that even on some of the most sensitive issues, the European Union and the United States can work together and find positive solutions to the benefit of both citizens and the economy. Of course, I may be biased having been a party to the negotiations, but I'm proud of what our teams achieved. Bruno will maybe say more about that in some minutes, but we managed to defend EU values and address the court's concerns. And we have tried to go as far as possible. Of course, it's not exactly the same system of protection in the US than in Europe. It's not the goal. The goal is the same level of protection, a similar protection that what we have, but we are taking into account the institutional framework in the US. Like we did the same when we have had to take an adequacy decision during this mandate about UK due to the Brexit. It was needed to take 2 adequacy decisions, or very recently with South Korea. Of course, it's not exactly the same system than in Europe, but it's the same level of protection. I'm quite convinced that we will have maybe a so-called Schrems III decision, because I'm quite sure that we'll have again some challenges before the court, but I'm quite confident that it will be a positive Schrems III decision to confirm that we have reached the goal to give enough protection to the personal data traveling from Europe to the US. Thank you very much, and I'm sure that you will learn more about that with the panel.
Indeed, thank you very much, Commissioner Reynders, for your very interesting remarks. which I think provide excellent background for our panel discussion, also with regard to the next steps. So this is exactly what we needed. Thank you, sir. Yes, thank you. So we have here a panel of distinguished speakers. I'm going to introduce each of them briefly. Before I do that, I just want to give recognition to a real giant in this field dealing with EU-US data transfers who passed away recently, and I'm referring to, of course, Professor Spiro Simitis, someone I was privileged to have known and who was a real giant from the early days of this, who was also a visionary and was someone who was always looking for solutions, not just saying no, 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 but really I think we all benefit from his pioneering work. Our speakers are all highly distinguished and experienced, and I think known to all of you. Their bios, I think, are up on the website, so I'm just going to introduce each of them briefly by one sentence. So, Bruno Gencarelli heads the newly created International Affairs and Data Flows Unit of Directorate General Justice and Consumers of the European Commission, and he is, amongst other things, responsible for negotiations on the new EU-US Data Privacy Framework. Anna Fielder is Senior Policy Advisor at the Transatlantic Consumer Dialogue, or TACD, and also President of European Digital Rights. Thomas Boué is Director General for Policy in EMEA of the Business Software Alliance, or BSA. Kristina Irion, Associate Professor at the Institute for International Law, for Information Law, at the University of Amsterdam. And last but not least, Peter Swire, Liang Chair of Law and Ethics at the Georgia Tech School of Cybersecurity and Privacy and the Scheller College of Business. Thanks very much to all of you for being here. We're going to run this panel a bit differently than maybe the classical way. We're not going to have any PowerPoints. We're not going to have set speeches. We're going to try to make this as interesting and as controversial as possible. So what we have agreed among us is I will pose a provocative question to each of the panelists, and I will ask them to respond in a maximum of 8 minutes each. So I will also hold them to the 8 minutes. I will be strict on that. And then after that, we will have some time left, and we'll take some questions from the floor. So our first panelist will be Bruno, and let me pose then my question to Bruno. Negotiations regarding a U.S. adequacy decision have been ongoing for over 20 years. Since then, 2 decisions have been invalidated by the Court of Justice, and the new decision, which, as we heard, the Commission is now considering maybe approving, will probably be challenged again. Doesn't the length of the process and the instability of adequacy decisions, as demonstrated by the 2 Schrems judgments, demonstrate that there are fundamental flaws in the entire approach for adequacy, and that the Commission should address this in its next evaluation of the GDPR in 2024? Bruno.
That's a light question to start with. So thanks, Chris. I will give you 3 answers, so that makes 2.5 minutes per answer. So let me start with the, some of you will think the boring, but the legal answer to your question. The requirements that were recalled by Commissioner Reynders have been set by the Court of Justice through an interpretation of the Charter of Fundamental Rights. They are therefore requirements of a constitutional nature. In other words, it's not a matter of legislative choice. And by the way, Schrems 1, first judgment that set those requirements, was, by the way, issued on the previous framework. So it's not a question of evaluation of the GDPR. This will not go away. This will stay. It's part of our, and for good reason, of our constitutional framework. But second, and looking now this more from a policy point of view, policy perspective, we have actually advanced our data flows agenda when it comes to data flows in general and adequacy in particular, and we have advanced it, and significantly, some will say, despite the Schrems 1 and 2 judgment, I would say, basing ourselves on the Schrems 1 and 2 judgments. And we have today, and some of these adequacy decisions were recalled by Commissioner Reynders, adopted adequacy decisions with strategic partners, such as Korea, Japan. We are negotiating right now an adequacy decision with another important partner, such as Brazil. Those things would not have been imaginable or feasible even a few years ago. We see also the development of new approaches to adequacy through a mutual adequacy arrangement, such as the one we have with Japan, such as the one we are negotiating with Brazil. A network of adequacy decisions that allow to go beyond the bilateral dimension this type of mechanism generally have. There are also many other work streams concerning data flows instruments we're working on. There was a very interesting panel this afternoon on what we're doing with ASEAN on sort of bridging our model clauses. So really, I don't think that this is the end of adequacy. On the contrary, it's a sort of renewal, an evolution of adequacy, which certainly is very much at the center of the core of our activity. And finally, and probably most importantly, if I may say so, we are not alone on this, or we are no longer alone on this. This issue, which has been discussed in so many privacy conferences, was very much seen as a Eurocentric necessity, proportionality, redress, national security. Why are they raising all this? And actually, today, there's an increasing common understanding at international level that we need rules of the game when it comes to governance access to data. As reflected, yes, in the EUUS data privacy framework, but as reflected in this unprecedented work of the OECD that led to those definition of principles, as reflected in the data free flow with trust initiative launched by the Japanese. And at the very recent Hiroshima summit, so the leaders summit at the level of the head of state and governor of the G7, it was decided to operationalize that or institutionalize that initiative, where trust is very much trust on how government access data. And what are these common rules of the game about? Substantive safeguards around necessity, proportionality, oversight, redress, not unknown terms, and not Eurocentric terms. And why is this? Because there's an increasing recognition that we need to ensure that trust, that you need standards for data to flow freely, but also because, and unfortunately because of certain developments, that privacy is increasingly seen as a key component of that dividing line between democracy, like-minded partners on the one hand, and authoritarian regime. And this was, for instance, also reflected in the Summit for Democracy co-chair by the US administration. So I hope I have convinced you that adequacy is not over, is not dead.
Okay, thank you, Bruno, very much. You're also well in time. I should say, too, I don't take a position on any of these questions. I'm just being the devil's advocate and raising them, but I think they all are fair questions to ask. I would just ask if anyone of the organizers is listening, maybe you could just ask the people behind us, directly behind us, to just tone it down a little bit, because we can hear them here quite well. I will now turn to Anna, and my question to Anna. Anna, the TACD statement, which I read, your organization, of 7th October 2022, on the announcement of the new EU-US framework, focuses mainly on issues of U.S. intelligence law and practice. However, one might think that individuals in the EU are more likely to be subject to profiling by U.S. internet companies than to surveillance by the CIA. When discussing EU-US data transfers, why is more attention often given to the practices of U.S. intelligence services than to the substantive principles under which data are to be processed in the U.S.? What is your view of the data processing principles of the Commission's proposed adequacy decision and their impact on consumers?
Well, thank you very much for this excellent question. And I'm itching to respond to Bruno as well, but I shall abstain for a while and answer your question first. The reason for that statement, it was because it was linked to the executive order of the president. But if you looked underneath, there were links to about 10 documents that addressed exactly the question you're asking, the commercial aspects, dating back to the safe harbor. In fact, the first ever TACD statement when we were created was on the safe harbor, which basically said don't do it because it provides lower standards and it's not helpful to US or EU consumers. So the short answer to your question, first, the data processing principles are substantially unchanged with some cosmetic enhancements. Therefore, our view that the agreement is not essentially equivalent to the GDPR remains unchanged. There's been a lot of research over the years about exactly that issue, how those principles are not observed, how they are weaker than what's in the GDPR, the fact that the agreement is voluntary, it's relatively small. If you look at the number of companies joining the Privacy Shield, I think they were under 3,000, maybe 4,000 on the maximum. And the most important point, it wasn't being enforced, as the Meta case demonstrates. So to answer your question about the impact on consumers, oh, and by the way, I'm not going to get into the details, the weeds of the actual principles, because they are brilliantly covered both by EDPB and the European Parliament comments. Just to say that, for example, EDPB, and we agree, points out that the actual principles are quite wide. They have a lot of exemptions, so there is a lot of possibility to bypass them. And also it mentions automatic decision-making, which I know, Bruno, you explain in the draft agreement, but that it is debatable. I just want to mention three important issues from our perspective. Oh, and incidentally, this adequacy decision, as far as I know, is the only one based on a voluntary agreement and not on a law. I think all the others are based on legislation. Japan, South Korea, New Zealand, and so on. I know that the Court of Justice said voluntary is good enough, but it is not from our perspective. Also, the Court of Justice hasn't been tested on the consumer side of things, only on the government surveillance side. So it would be interesting to see if Schrems 3 goes on to consumer issues as well. So two more issues I'd like to mention. The first one is this redress. On the commercial consumer side, there are 7 avenues of redress. But principally they're based on complaints to companies and companies' own redress mechanism. I would ask you and the audience, what normal person, assuming they know what's going on behind the bonnet, because all the infringements are not very well known and they happen in private, so what ordinary person will start reading all these 7 methods and go and complain when these infringements happen to thousands, if not millions of people? So what you need is a private right of action, class action, collective redress, not an individual going on to 7 avenues of redress. My final point, which is actually the most important one, we have a saying in Romania, why scratch yourself like this when you can scratch yourself like that? The best avenue to achieve adequacy with the US, and it would be an advantage to both US consumers and EU consumers, is to enact privacy laws in the US. And there's been a huge advancement on that front. There was a law in Congress, I think this is called the American Privacy and Data Protection Act, that was bipartisan, past the committee stage, I believe, and it suddenly floundered. Maybe Peter will explain a bit more to us. That would be good for US consumers, good for EU consumers, and it will probably ensure better enforcement for all of us.
Okay, perfect. Thank you, Anna. Again, perfectly in time. And I think so far we've seen it's possible to say quite a lot in a short period of time. I've already seen some interest perhaps among the panelists and maybe responding to each other. So assuming we have enough time before the Q&A, I might give a couple of minutes to ask if any of the panelists want to just respond to the points that another panelist has made. But I will now turn to Thomas. Thomas, let me ask you the following question. Following the invalidation of the safe harbor, numerous commentators warned of the dire consequences that this could have for transatlantic trades and services. And these warnings were repeated following invalidation of the Privacy Shield. However, according to a paper of DG Trade of the Commission in 2021, both transatlantic trade and transatlantic trade in services reached all-time highs. Therefore, couldn't one question whether this never-ending debate about EU-US data transfers has any real-world impact?
Thank you, Chris. That's an interesting question, because what the study from DG Trade doesn't show is what could have happened should we had a proper and sustainable arrangement. So, we look at it from the perspective of enterprise software companies that help in the digital transformation of every single sector of human activity, not just in the economy, but also for society at large. And what we're seeing is data flows are increasingly important, and the single most important issue for all of these organizations that actually have customers, vendors, supply chains all across the world, and they need to communicate, they need to exchange. And so data flows, finding a sustainable solution is extremely important, because since the last two cases, what we've seen is a lot of uncertainties that have led to a lot of confusion. And I just want to mention sort of two of them. One of them is, and at least from the perspective of industries and industries that are helping in digital transformation, is questions from customers. Business customers, government customers, which is, hey, where is my data? What happens to my data? Who has access to it? These are legitimate questions, and they are important ones, but they're adding to a flow of discussions. And we're seeing a lot of companies explaining, as has been done, in the case, for instance, of what was in Schrems 2 with the standard conditional clauses, what are the additional safeguards that companies add in order to protect data on a case-by-case basis. At the end of the day, this is what we have to remember. When we're using SCCs that was mentioned by the commissioner, it's not just a blanket approach. It's what kind of data, to which destination, for what purpose, in which context. So having these safeguards looked at individually, it takes time, takes a lot of explanation, but that actually needs to happen. And that actually creates a lot of discussions. What we've seen also is some sectors, some companies, some organizations actually are discouraged in digitalizing, in making use of the tools available to them, because it's too much of a headache and they don't understand, and it's too complicated. The second thing, and maybe this is the most worrying one, is we're seeing calls for data localization across the board, including in the EU. We've seen EU policies put out by the Commission that pushes for data localization in Europe. It's the case, for instance, in the Data Act, which is arguably makes no sense. For non-personal data, having this creates very, very much headaches for companies. Some of these calls, and let's face it, are also purely protectionist. We're seeing that in the context of cybersecurity as well, where you have certification on cloud computing that would impose a localization of data in the EU if you want to be certified, reducing the pool of technologies available for customers and in the end for citizens. So these are real concerns that we are seeing that are still being addressed, that are still going through the motions. And what's the worst the most interesting in this space, and Bruno mentioned it very well, this is not, all these cases are not about what the companies do with the data. I think we have GDPR for that. We had the 9546 before that. It is enforced. We're seeing the reports coming out. There's a lot more enforcement happening. The real issue at stake is government access to data, third country government access to data. And short of a government-to-government action, we will face numerous, litigation and numerous actions, and still, these uncertainties that will fly high over our heads. So Bruno mentioned it, and I think this is very important to notice. There's extremely good work being done by the OECD on the trusted government access principles that were adopted last December. There's enormous work that has been ongoing in G7, first by the United Kingdom, then by Germany, now Japan with the DFFT, which we fully support. We need to get governments to agree on the necessity and proportionality test for access to data for legitimate purposes, national security, law enforcement, etc. We also need them to agree on what are mechanisms for redress, mechanisms for giving solace in order to move forward. So, we're fully supportive of the new data privacy framework with the United States. We think that what the Commission and the United States have done really addresses the points raised by the courts. We're putting a lot of hope in this new court and all the privacy policies being implemented at the national security agencies level. But the work is not done. We need to get governments to agree. We need them to have them operationalized. I think Bruno mentioned it in the context of G7. The institutionalization of these principles are the clear thing that is needed in order to avoid these uncertainties and all these rocky roads ahead.
Thank you very much, Thomas. Again, very much in time and a very clear response to my question. I will turn now to Kristina, and I will ask her the following question. Kristina, data transferred to the U.S. do not necessarily remain there always, but they may be transferred on to third countries. Such onward transfers, as they're called, have long been a point of contention going back to the safe harbor. Now the U.S. has joined a group that is promoting so-called global cross-border privacy rules as an alternative basis to transfer data at the same time that the Commission is preparing to issue a new adequacy decision. How should the new EU-US framework deal with onward transfers of data from the US so that fundamental rights are protected, and is there a risk of conflicts between these different data transfer systems?
Thank you, Chris. This is an exciting question because data is extremely liquid. It can be easily transferred from one country and the next, and the new or the forthcoming EU-US data privacy framework is going to address the relationship between these two countries, but that doesn't mean that the data necessarily stops there. And I was very pleased to see that the draft adequacy decision lays down a strong fundamental principle that says that the level of protection afforded to personal data transferred from the Union to organizations in the United States must not be undermined by the further transfer of such data to a recipient in the United States or a third state. And that makes, first of all, a good principle because also within the United States, the same data could be transferred onward to yet another controller or agent, which is a possessor in the jargon of this data privacy framework principles. And also yet other third countries. Now, interesting is to see how this is implemented in the new framework. And I was looking a bit more careful in how they want to achieve that the data that has made the first hop over the pond and is then arrived in the United States stays and is still protected in line with the high standards of protection we are used to in the EU. And here we see that there is a dedicated principle which is called the accountability for onward transfers principle. And we have also a supplemental principle which requires obligatory contracts for onward transfers. Now, that sounds first of all quite strong, but then looking a little bit more deeper, we realize that the situation of agents or possessors is very well covered. These agents should never have the mandate and the legal possibility to themselves transfer the data onwards. But when a US controller that is certified under this new data privacy framework principles is deciding to share this data, personal data, originating from the EU onwards to yet another controller, we see that the safeguards are starting to become weak. Because here, there still needs to be an obligatory contract, but I quote, that for these transfers between controllers, the recipient controller need not to be a participating organization of the safe harbor or of the data privacy framework principles, or have an independent recourse mechanism, provided it makes available an equivalent mechanism. Now, what that means in a nutshell is that, in fact, the new data privacy framework is a government-backed scheme in the US. Organizations self-certify, they are becoming admitted, they can receive EU data when they are complying with these principles. But when then these organizations are giving the data yet to other recipients, these are no longer certified, they are getting it with a contract, there is no longer a state-backed system that exercises some sort of control, and also the Department of Commerce or the FTC will no longer have jurisdiction to enforce that, because this is a private contract between two private sector actors, and the FTC is not going to enforce that. So what I mean to say is that it is having quite some gaps, this new framework, when it is about the second top, not the first, when the data is arriving in the US, but when this controller decides to hand the data over to yet other controllers. And that is a legal risk, obviously. And when it comes now to the interoperability with yet other international data transfer tools, then we must establish that, of course, because the US itself doesn't have a federal data privacy law, it is not so easy to plug in with other data transfer rules. So we are seeing that especially standard contractual clauses are becoming the workhorse of international data transfers. We are seeing the promising developments with the ASEAN binding contractual rules, and also the Ibo-American standard contractual clauses. So there is becoming like a new template that is like a network of private sector contracts that are used as the framework or as the basis for keeping to transfer personal data. However, with the US, this is not so simple, because they are not having a domestic data protection framework that would really back the contract. So I am also a bit skeptical whether we can simply plug and play, for example, with the just referenced global cross-border privacy rules, which have a lower level of protection than what the EU-US data privacy framework envisages. And my last comment is a little bit about the framing that data flows is like a natural entitlement for businesses to participate in the digital economy. I think this is not true without also adding the caveat that there's an overriding public interest in protecting personal data protection of individuals, which are fundamental rights. Therefore, this entitlement doesn't exist like this, but we have to tweak it in order to make it fit in this highly globally interdependent digital environment. And for that reason, it is possible to basically look critical at how we want to enable data flows between different countries. And some countries are simply more suitable as partners than others. And here we have to say that the United States legal system is an outlier, because they are still not yet there with their own data privacy framework, which, as Anna rightly said, would also benefit the domestic consumers a lot. And finally, some of the role models that are currently discussed, like the Data Free Flow with Trust initiative, which is backed by Japan, but also very much promoted in the context of G7 and the G20, is something that at the moment nobody can really explain how to get the trust into the free flow. Yeah, it is a very strong statement and principle, but even here we need data protection laws to really bring the trust, and the flow in itself is not going to solve it. Thank you.
Oh, thank you very much, Kristina. So many interesting issues. I was just dying myself to comment on them, but I will resist the temptation and instead go to our last panelist, last but not least, certainly Professor Peter Swire, with the following questions. Peter, you have been involved in EU-US data flows since this whole issue arose in the late 90s, so we could probably say 25 years that this has been going on. Since then, the pattern has been that the EU and the US reach agreement on a framework, which the US says is the farthest it can go. The adequacy decision based on the framework is invalidated by the Court of Justice. Another agreement is reached with the US, again saying it has gone as far as it can. This is again invalidated, et cetera, et cetera. As privacy law seems to be evolving rapidly in the US, is this latest framework really the farthest that the US can go? And what is likely to be the reaction in the US if the adequacy decision underlying this latest framework is invalidated again?
Thank you, Chris. Is my mic on? Hello? Okay, good. Well, so you're saying it's been one failure after another, and here we go again, I mean, roughly speaking. And I have some different perspectives on that. One is Safe Harbor. I was the privacy official in the White House in the late 1990s when we negotiated Safe Harbor. And in the 15 years after that it stood, many US companies began a process of treating personal data from the EU as under EU level protections. That was required by law under Privacy Shield, more or less, not perfectly. And that was a big step towards saying US companies and other companies have to have EU level protections. So not a complete failure. In terms of the current data privacy framework, I have very different views towards necessity, proportionality, and redress on whether they really, whether the US has gone as far as it potentially could go. So on necessity and proportionality, the US has made quite a few changes. Alex Joel, who's here, just published a study this week about why the new rules really seem to meet necessity and proportionality. But I'll say it this way, maybe as a teacher. So imagine the US made 10 changes to necessity and proportionality. Some might think it only had to make 8 or 9. Others might think it had to make 12. Like exactly what's necessary and proportional, we all know it's like reasonable. It could be a little more, a little less. If the court were to say you got 10 right, but you need 11, quite possibly 11 could be done. But I think redress is quite different. And this is where I've spent, along with Professor Theodore Christakis, who I think is here, and Professor Ken Propp, we spent most of 2 years trying to work on redress, and including trying to write, and Bruno Gencarelli is here and has had to listen to us on this topic. And in this, I'd say that the following as context. US lawyers have had to learn a lot about EU fundamental rights law. There's a lot of US lawyers here, there's a lot of people. And what I'm going to say now is that EU lawyers may need to look at this, to look a little bit at US constitutional law, because we're a rule of law democracy that has to follow the Supreme Court. So on that process, there's 3, and I'll emphasize 2 places where the US Constitution really kicks in with recent Supreme Court cases. One of them is on this issue of standing. So a federal court can only have a private right of action if the plaintiff has injury in fact. That's constitutional law, and in 2021, the Supreme Court said it again in a privacy case and put a pretty strict requirement of actual injury before you can get a private right of action. And as of today, I've not seen any proposal in Congress by anybody that would let any EU person come and sue in the federal court. I haven't seen a proposal that does that. There's been some that have made, and I've tried to explain why they don't work. So I don't see, as a law professor who's worked on these issues for years, how you get to federal court with a redress proposal, because every EU person, even those never injured, has to have the ability to bring the complaint. You can't do that in federal court. If you can't do it in federal court, then you have to go somewhere else. And the logical place is the executive. And so the second hard issue is, how can you have the executive branch create something independent? And to European lawyers, in my experience, that sounds paradoxical to the extreme. It doesn't sound possible. But we have another 2021 US Supreme Court case. It's called Arthrex. And very briefly, what the case says is, Congress wrote a statute it said there would be independent judges to look at patent disputes. The head of the patent office couldn't overrule them. The Secretary of Commerce couldn't overrule them. They were the final word on patent disputes. The US Supreme Court said that is unconstitutional, cannot do it. And the reason is, they said, there has to be a politically accountable official overseeing decisions like this in the executive branch. So that's even worse for the Europeans. How are we going to have politically accountable officials and independence? And then over a course of 2 years of working on these issues, professors, the US government officials, poor Bruno, had to learn about other ways the US has worked on these things. And so there's a special idea where the Department of Justice issues regulations, a legal thing, and the Attorney General steps back and say, I can't touch it anymore. The regulation says there's independence. And we have a Supreme Court case called Accardi, where the deportation decisions were left to the independent judges under the reg. The Attorney General said, no, I don't like your deportation decision. The Supreme Court said, you have to follow the law. The law is the judges win, the Attorney General loses. And that is the structure of the executive order, of the regulation, which is the Attorney General has given up some of his authority in a reg. The President has given up some of his authority in the executive order. Those are issues of law under US law. Executive orders and regulations are law. And tomorrow they could change it, but if they change it, take away adequacy. But today, while they're there, you have a regulation in place to protect this. You have an executive order in place to protect this. And at the end of that, you actually have independent decision by these judges who have independence, protected by Supreme Court decisions. I could say more. There's the foreign affairs issues and Executive Order 12333. But the point I'd like to make is, and we're working on in Friday's panel, I'll be talking about some of this in more detail. The point here is there are recent US Supreme Court cases that create real constraints on what the US government can do to meet European standards. And so if you ask for a statute for independent judges, that won't work, Arthrex. If you ask for a private right of action in federal courts, that won't work, Ramirez. And so that's where we have our Supreme Court that we're facing. I'd rather have different decisions by our Supreme Court, but we're a rule of law country who has to follow our Supreme Court as well. And so that is a context where I have seen no proposal, literally none, not even close, that shows how redress can do all of European law and all of US law, other than what the executive order does. If the Court of Justice strikes down the redress proposal, we literally don't know, consistent with the Constitution, what else to do. On necessity and proportionality, there can be different discussions. But on redress, I don't see another path after having spent 2 exhausting years trying to find one. So I'll stop there unless you want a minute on US privacy law, but no. Okay, I'll stop there.
Thank you. Thank you very much, Peter, again, for a very, very informative response. I think you've all been the dream of a moderator because you've all really stayed within your time limits and you've responded to the questions. I think now, I know at 6:30 we have a cocktail hour, and from looking at some of you, it looks like you may need some sort of refreshment. So I don't want to, I'd really like to try to end this on time, but give you some time for questions. I guess my only response sort of as an observer to listening to all of you, which something that's very interesting that I think is not often picked up on, is this whole long discussion of EU-US data flows seems to me really the world's longest running comparative law exercise without it being characterized as that. But it really requires each side, the US and the EU, to evaluate and learn about each other's systems and particular fundamental rights systems. So in Washington, they're talking about EU constitutional law. Here we're talking about US law. So it's really interesting from that point of view, I think. I will now turn the floor over to questions. We do have a little over 10 minutes. Now, the last thing I want to do is inhibit anyone from asking questions, but I do want to set out some parameters just to make this most efficient and to leave the most time for questions. So, first of all, I think the organizers would like it if before you speak you have a microphone. either one that someone gives to you or you come down here. I would also ask, please identify yourself, to say who you are or where you're from. Please also try to be brief, and really very important is really try to ask a question to one or more of the panelists. Please don't go off on a long rant or make a speech. Please have some sort of question in what you say. And I will try to be strict again, just as I was with the panelists with these rules. So with that, I would throw the floor open to anyone who has a question for any panelists. Yes, I see one here, and then I will go there.
So Commissioner Reydner said, Ilya Vasilenko, WeFox, DPO. Commissioner Reydner said that intelligence authorities, they will have to adopt their rules for the adequacy decision to be in place, in force. So speaking about American companies, so what is expected that American companies will have to do to be compliant with adequacy decision? And we in Europe here, how we would be able to validate if a certain company is compliant with this adequacy decision?
Okay, very, very practical question. Maybe we'll take two questions and then respond. So I think the second, Laura Drexler.
Yes, so I'm Laura from Karl Leuven and also the Open Universiteit. I had a question because now data transfers seem to be more and more regulated also in trade agreements, and there was always this parallel, but I feel now you really see this more and more. And there's also this proposal to try to regulate it at the level of the WTO. So I would love to hear the opinion of the panel on the relation between data transfers, which is this very fundamental rights issue, and trade law.
Okay, thank you to the questioners. I'll ask the panel who would like to respond there. Bruno.
On the two questions, but certainly on the first one, because it's a technicality of the data privacy framework. So data privacy framework is based for the companies importing data in the US on a system of certification. They have to be certified by the Department of Commerce. Yes, it's voluntary, but then it's become binding and enforceable, including by the FTC, and I think nobody doubts that the FTC is a strong enforcer. And therefore, those companies are certified, that is made public, including on the website of the Department of Commerce. It was 5,000 companies, more than 5,000 companies last time. But what is also important when it comes to data privacy framework, that it will not only, its safeguards when it comes to governance access, necessity, proportionality, redress, will not only apply to transfers under the adequacy decision. They will, and I think Commissioner Reynders indeed recall it, they will apply to all transatlantic transfers, because now, and those representing company will certainly make that point, that you have to do a risk assessment. It is complicated. Why should companies be responsible for how intelligence laws work in one jurisdiction or the other? Now you have a guarantee, and that's very important in light of the decision of Monday. You have a guarantee that there's a redress mechanism in the US and that there are safeguards around necessity and proportionality. Very short on trade, because this is another important aspect of our policy. Data protection is a fundamental right. The transfers of personal data cannot be regulated to trade agreement. Data flows can, when it comes to personal data, can only take place on the basis of one of the instruments. By the way, they're all voluntary, most of them, listed in the GDPR, standard contractual model clauses, ad hoc clauses, BCRs, etc. But we have certainly increased the synergies between trade agreements and our privacy instruments. How did we do this? By, in a certain way, striking a balance between our offensive interest, is that we want to trade agreements to address some protectionist measures, in particular localization measures that sometimes invoke privacy but are not there, not put in place for privacy reasons on the one hand, and on the other hand, protect our regulatory autonomy. The EU, as its commercial partner, should autonomously be able to set the level of protection without this being challenged or questioned in a trade context before a trade dispute settlement body. So how do we achieve this? in all our trade agreements, all the trade agreements concluded and negotiated by the EU, you have now a chapter on digital trade that contain straightforward prohibition of certain unjustified obstacles to digital trade, in particular localization measure, and on the other hand, has a very clear provision saying that each party shall be free to set the level of protection at the level it considers appropriate without this being subject to trade test and to trade dispute settlement. That is not only a nice idea and concept on paper, it is in the EU-UK TCA, it is in the agreement we have concluded, the free trade agreement we have concluded with New Zealand and with Chile recently, for instance, and it is also the basis for our negotiation at the WTO on the e-commerce negotiations.
Okay, thank you. Anna, I know you'd like to say something.
I think Bruno has been very comprehensive on trade. Yes, he's right. The current negotiations at the WTO have floundered exactly on the privacy and the data transfer issues. Just to give you a good example of what's happening currently in the UK, who is unfortunately no longer in the EU, they're now modifying their data protection laws precisely for trade reasons, to weaken them. Laura, you probably know that, precisely to weaken them in order to join other global agreements that have weaker standards. So, you know, hopefully that's not going to happen in the EU, but let's see what happens. I just wanted to add another small thing on the first question, and it is a pity that the Federal Trade Commission is not here. As far as I know, they're not getting extra resources to investigate and police this. They are doing hugely broad and important work. The past experiences that the past agreements have not been enforced effectively. So that's a big question mark on how this agreement is going to be enforced when the US agencies are busy, so busy on their domestic level. And the other point I wanted to make is that this agreement does not cover everything in the US, and Peter will know much better than I do. There are a lot of sectoral US laws that are not covered by this, and that includes financial services, health, and so on. And those laws have not been modified or updated since the 80s, I think. So, you know, it is not such a big agreement.
Okay, there were two other questions I saw. One was someone right here, or was it, I think it was you had your hand up earlier, and then there was someone in the back here. So please, yes, please ask your questions, and we'll try to have as much discussion as we can. Sir, would you like to ask and identify yourself, please?
Yeah, thanks a lot. I'm Sebastian Dano from Kala International. I will be very brief. How sure or unsure are the panelists that the DPF will withstand a legal challenge before the CJU?
Okay, important but brief question. And up there, could you wait till you get a mic and then ask your question?
Hi. Hello. Yeah, I'm Jaime Spenton from the Norwegian Tax Administration. It's not a question, neither a rant. It was just a comment to Mr. Swire's concern about the redress. And one thing about redress that we've not... That
could you speak up a little bit, please?
Yeah, one thing about redress that no one has mentioned is that Europeans have redress recourse in their countries in Europe as well against American companies. And it's something also that is foreseen in GDPR. It was just that comment. Thanks.
Okay, thank you. I think, who wants to respond? Peter?
So on who will win, obviously, as an American lawyer, I'm the worst person to predict what will happen in the CJEU. But what I have tried to point out today is if the redress goes down without there being some other proposal, we'll face a constitutional conflict of law. If EU fundamental law is inconsistent with the US Constitution, so far as I know, that's never been an issue the courts had to deal with. And so that is when essential equivalence might have particular force. And then on who will win on necessity and proportionality, I have less to say, but a constitutional conflict of law would be no small thing. Asking the US to change its constitution as a condition for data flows would not be a small thing.
Can I, very briefly, probably you suspect what I'm going to say, but on redress, just a footnote. It's important to note, because you know, when I hear this discussion, I really have the impression, we are a small group here, so I can say, it's never enough. No, it's never enough. Proportional necessity, you will never obtain this from the US. Redress, forget it. Standing, problems, whatever. We got this. We got this. The EDPB on redress said that there's no reason, and believe me, I've been sufficiently long in this job to know each and every nuance of the EDPB, and before the article, they said, I've never seen them so clear, there's no reason to doubt on the independence and impartiality of the redress mechanism. I don't remember the number of the page, but you can all check that tonight after the cocktail. But so on the, meaning I'm not here, I'm a public official, I'm not here to speculate on what kind of case will be brought before the Court of Justice, what the Court of Justice will say. And you will tell us, and you will tell me, yeah, last time the Commission also said that it was good enough. Well, there's a big difference. There's a big difference. Schrems 1, we were invalidated because we hadn't looked at something nobody thought we had to look at, not even the DPAs, governance access to data in the context of an adequacy decision. You have to follow the data to its whole life cycle, including in the scenarios in which it could be accessed. Schrems 2, the court, which didn't necessarily make the negotiation easier, but the court was much more detailed on what we had to find, what we had to negotiate. That's why we had, and I think this is also the expression used by Commissioner Reynder's, a mandate. The judgment, the Schrems 2 judgment was our mandate. And therefore, during the negotiation, we had much more clarity on what we needed to obtain. And we will be, and that's why also we believe in case of litigation, we will have a convincing case and we will be able to defend it against the series of criteria set by the Court of Justice in its Schrems 2 judgment, and also in other judgments that have been adopted by the Court of Justice in the meantime, and that concern these same issues within the European Union.
Okay, thank you, Bruno. We're really out of time, but I'm going to give the last word to Thomas Boué.
Just two things. We get back to Laura's question because it is an important one on the trade elements. I think, as we said before, it's been said many times, I think we're seeing forced localization of data for protectionist purposes. Have nothing to do with protection of personal data or fundamental rights. This is a real problem and it needs to be tackled, and trade law is one avenue to tackle that. On the second one, just to add to what Bruno and Peter were saying about the viability of this third agreement, I think if we think that this agreement once and for all and we're done and we sit on it, I think we're doomed to fail. I think what we've been saying consistently is that this is being looked at. There will be review mechanisms. There's all the work that goes on at OECD, at G7 that will feed into that actually will inform that. And I think as these issues are front and center and continue to be worked on, I think there's hope that this sustain and will be, we will be in clear water and calmer water soon.
Okay, thank you to Thomas. Thank you to all the panelists. I'm sorry for those of you who couldn't ask a question. I think we've had a really interesting panel. It's obvious the party has already started, and I don't want to keep you from there. I would just say one final prediction I can make is, even assuming that the Commission issues its decision, assume it's upheld in a Schrems 3 judgment, this is not going to end. This will be going on probably long after I've left the scene. There will be some other EU-US disagreement about some data issue. So this will keep all of us in work for quite a while. Thank you for your attention, and enjoy your reception now.